mediation panel, and we've got a variety of perspectives to talk about that today. And I'm here just to introduce the panel to you and before we get going. So we have with us on the end Judge John Borg. He's a special master, mediator, arbitrator, and qualified neutral. He has experience with many, many types of litigation and disputes, including commercial, intellectual property, products liability, business torts, and many, many others. So welcome, Judge. Next to Judge Borg is Helen Preddy. Helen is the president and CEO of U.S. Arbitration and Mediation of Minnesota, where she is both a mediator and national trainer of mediators. Since 1988, she's been mediating for the federal and state courts as well as private corporations and individuals. And in 2006, she was appointed by the Bankruptcy Court in Portland, Oregon, as one of 4 mediators to work on the Archdiocese of Portland sex abuse cases. Welcome, Helen. Next to Helen, Dan Simon. Welcome, Dan. Dan's a highly experienced transformative mediator and trainer. He's a chair of the ADR section this year, and he's also a member of the Supreme Court ADR Ethics Board. I also believe Dan was the first mediator who was certified as a transformative mediator for the Postal Service, which is not the Rule 114. There's no certifying there. But so, yeah.
Well,
so
it's
great.
not exactly the Postal Service, but the first certified transformative mediator, which it would be great if there were more of them.
Yeah. Great. Excellent. Thank you. And our moderator is Jeff Ansel. Jeff is a shareholder with Winthrop and Weinstein. He practices in the areas of business and commercial litigation, real estate, creditors' remedies, and bankruptcy law, and also ADR. He has a niche practice with receiverships, and also, as I know well, recently helped to draft our new receivership statute. So with that, thank you very much.
Thanks. Good afternoon, everybody. Thanks. It's after lunch, so I hope we can keep you all awake. A few weeks ago, when Dan approached me as the potential moderator for this presentation, Dan said, "Who do you think would be good for the panel?" And I said, "Well, Dan would be good for the panel. Dan is the chair of the ADR Section Council of the Minnesota State Bar Association this year." And I said that I knew Judge Borg when I have cases that I don't think stand a snowball's chance to settle. I call Judge Borg and we settle them. And I also suggested that Helen Preddy be on the panel because I was trained in mediation by Helen, and I know a number of my partners rely on her heavily. And as I told Dan, I said none of the people on the panel should be shrinking violets, and I think we accomplished that goal.
I think you did.
So the topic is commercial mediation, and we thought that the best way to do this would be sort of question, answer, and audience participation. It's very informal. Please, if you have a question for any of the panelists, please feel free to do so. I've got a few questions I'm going to ask them about different approaches to commercial mediation, because there's a lot out there now about whether we have really established a patterned dance for commercial mediation. You caucus, you don't caucus. Those are some of the typical questions, but really the approaches can be different, and there's I think a call for some creativity out there in how we approach these things. I think each of these panelists brings that to the table. So I have to take my glasses off to read now. It's a function of my age, I guess. So the first question I want to ask the panel is, for each of you, do you have a philosophy of commercial mediation? What is it? And if you don't have a philosophy that governs how you mediate commercial disputes, what's your definition or description of what a commercial mediation is about? Dan, go right down the line here.
Well, the way that I look at that, which I am not sure how different it is from how Helen and John look at it, I hope it's somewhat different to make this interesting, but the way I see my role as a mediator in a commercial case, or any case for that matter, is that I have the potential to help the parties have a higher quality conversation than they've had in a while. I do not see achievement of settlement as my goal. I see it as a wonderful side effect of a really good conversation, because when people have a chance to get as much information as possible from each other, and they have a chance to express some of the anger to the extent that that's part of the story, they get to a place where they're able to just do better problem solving and make better choices about settlements. And I wouldn't want them to settle because I was really good at getting them to settle. I want them to settle because they've had the kind of conversation that allows them to feel good themselves of their own volition, fully self-determined, in coming to a settlement. That's what I got for starters.
Thank you. Helen, how do you view that topic?
I would have to say every time I get a new commercial mediation, it's going to be a different dance, really, because there are going to be different people. And so sometimes they'll start out together in the same room and engage in a conversation. Sometimes they'll start out with me separately in separate rooms and do a conversation. Then I'll get them together at some point when I find that it's fruitless. As I say, I like to remind them, the only person really making money at that mediation is me. And so I'm running back and forth, you know, trying to convey messages that they could convey to each other. So I pretty much will get them back together. But as I say, you know, I have no fear of, I was raised in a Cajun household. We yelled when we were expressing table conversation. So it doesn't bother me when people yell. And so to me, it's a work in progress. I'm there. I tell them, this is your show. I am not there to settle this case. It's your process. And I was telling Dan earlier, I had a call this year, and some people said, we'd like you to come mediate this case. We've already mediated once, and the mediator was terrible. And I said, the mediator wasn't terrible. You people were not ready to settle. And so, you know, it's like, hey, we're just there to facilitate the conversation. We're not there to do anything big. So for me, it's a dance.
Judge Borg?
Well, I can make it short and say I agree with Helen. Mediators don't settle cases. Parties and lawyers settle the cases. And people frequently ask me what I do, and I say, well, gee whiz, I try to help people save themselves from themselves. There are just perceptions that people have about the litigation process that is television and movies, which, as all of us know, because we've spent time in the courtroom, we're a universe away from that. So,
Well, I hear each of you talking about the sort of the concept of getting a good dialogue conversation going. So I wanted to just follow up on that and ask the question, what do you do when one of the parties is there because he or she has been ordered to be there? Or what do you do when you can't get that conversation going because counsel is dominating the conversation and saying stating the position of the client? How do you break through those barriers to get the parties talking about whatever it is they need to talk about? Let's start at the other end this time.
yeah, well, if one of the first agenda items for me is, why are we here? Are we here because the court's ordered it? Are we here because there's some law of the case now that has changed its complexion, or it should have changed the view of the case by one side or the other, or both? Are you running out of money? I mean, what are the things that motivate you to be here? And getting through the one where they say because the court ordered us to be can be somewhat difficult. And we spend a fair amount of time doing the dance because that's information that's really essential for us to begin to cut through it and get people to have a meaningful conversation about resolution. So it's usually just a real nice little chat sitting in the room with them and understanding why they see this as something you're doing because they have to, as opposed to seeing any advantage in it. So then I have the discussion with them about, well, all right, we're here. I mean, we're all committed to the day. I charge you a 4-hour minimum. What the hell? Let's we can at least get it to lunch, but let's talk about that. And I have found typically in those conversations, people really aren't usually there because they have to be. I mean, it's nice to be ordered there because they get to say, I'm here because I have to be here. But if you can crawl behind that, you'll find out usually that, no, they're there. They'd like to do a deal. But they don't want to be the first one to say that, because then it's the sign of weakness thing, that whole deal. You never want to make the first offer, all that kind of crap. But we have to deal with it all.
What was the question?
How do you overcome the barriers getting that conversation going?
Interestingly, I think that one of the things that happens is that attorneys now have become more evolved, where I don't really hear that as much. The clients might wonder why they're there and wonder what the process is going to look like. And so I will go in and meet with them either together or individually, and I'll say, this is an opportunity for you to get back to doing what you really do, running a business or whatever they participate in. So, we're going to go ahead and give it our best shot here. And, I don't really hear that so much. I find that I ran a preschool before I went to law school. I'm doing the same thing now that I was doing then. And so I find that I spend a lot of time explaining to the non-lawyer party what we're saying. I always say to them, if we sound like we just landed from another planet, bust in and say, Helen, John, why are you talking the way you're talking? Explain this to me. So we talk about it in terms of that, and so I have the lawyer explaining a lot to his client what he or she is really saying. And then, we talk about, I don't really have to care if it settles or not. And if I don't have to care, then, they can go ahead and we'll talk about how much money they're going to spend going forward, what happens if they win, what happens if they don't win, how much will they have to spend. We talk about all that kind of stuff. We also talk about who the judge is that's presiding over that, because, they might be some real nice, well-meaning public defender. And we're dealing with a commercial case. So we talk about those kinds of things. We talk about everything. We talk about making gumbo. I mean, we talk about everything. So yeah, I think that you have to keep them. I really do believe this. I think the more relaxed we keep these participants, the more action we get. And that's what I think we should be doing. Having a good time, and, even when they're not, I'll say, are we having fun yet? And they're like, oh, yeah, this is really a lot of fun. And I also love those statements that they make where they'll say things like, I am not paying 6 figures. Do you understand? I always say, I got it. And many times I walk out and they paid way beyond 6 figures. But I like to acknowledge that they've said it. That's fine with me. I don't care. It's good. So don't believe anything you hear, because we're just moving along on a little train. It's fun.
Dan, you have kind of a different approach on getting people to communicate, I think, don't you?
Well, you do.
I think so, but it doesn't sound that different from the way these two are talking, which is disappointing.
He's so sad about this. He wanted them to fight. Really.
Well, let me just say that I guess I've done a handful of commercial cases, and in those cases, the lawyers who arrived were very surprised when I suggested that, well, for starters, just for efficiency, if I can give you my introduction with everybody present. And they said, well, and then we'll go separately, right? And I say, your choice. We can do this any way that feels right to you. As far as I'm concerned, my job is to help you have the best possible conversation. From what I've heard from anecdotes, and unfortunately I don't have any anecdotes from these two mediators themselves, but what I've heard about other commercial cases is that the assumption is that the parties generally don't talk to each other. Again, I'm hearing that that's not necessarily the case with these two. But I guess that's the thing that I'm most concerned about out there, that it seems, from the rumors I hear, that there are mediators who are very focused on settlement as the outcome and not so much on the quality of the conversation between the parties. In fact, the assumption is that any talking directly between the parties can do harm and it can get escalated, and so better to just keep them separate. So I'm not hearing that from these guys, but so I'll fight with the other mediators out there that I've heard about. I agree, and I agree with John said that just because somebody says they're here because they're court ordered doesn't mean that's why they're here, and absolutely, I find it appropriate to let people know that as far as I'm concerned, you have satisfied the court order by showing up, and as far as I'm concerned, we only continue for as long as you want to. So keeping them in control, helping them stay as relaxed as possible by not seeing it as our role to push them anywhere,
Right.
but just to support them in doing what they want to do. So unfortunately, I agree with those two on all that.
All right, so, but
Well,
oh, I'm sorry, go ahead.
Well, then I usually, move into the discussion about, I know you're here because you got to be here, but let's talk about why it's a good idea to be here seriously. And then, it's not quite the way you say it, but you go into the parade of horribles, and if you think this is fun, wait until you're sitting in court for a few days. And it's not a frightening thing, but it is to lay the groundwork for people to understand what they don't understand. And unless you've been in the practice like all of it, we all know what's going to happen when you go into court. You barf before you go in there because you're still nervous. Doesn't matter how many years you've been doing this stuff. And but the clients don't know that. You can tell them about it. They can read about it, for God's sake. But it's still different. And I think part of what we can do as a mediator is to help people understand what's going to happen downstream and why this is a great opportunity, and to persuade them that while you're ordered to be here, which is fine, let's take advantage of the situation. And you never know what can happen here if you don't engage, if you don't get in the process. It can be cheaper than you think. It can be quicker than you think. You just don't know. But if you don't play, how are you going to know? Now, there are people you run into who don't care. And in fact, not only do they not care whether it settles, they don't want it to settle. Sometimes it's a party, sometimes it's a lawyer, sometimes it's both. And there are all sorts of motivations for that. And you got to try and sort through those. And then we try and figure out, okay, how do we burn down that fuse and get them here to play for real? You know, the other thing is, and as Bob Weinstein always says, I got to give attribution where it belongs. He says, mediation is not an event. It's a process. Mm-hmm. And I'll bet you 25% of the cases that ultimately settle that I've mediated don't settle on the day of the mediation. I'm screwing around with them for weeks after that. Email, telephone, coffee meetings, just all of that stuff. Yeah. I've had cases that have taken me 18 months.
Well, when you talk about how sometimes the lawyers don't want to settle, so that's a really an interesting, raises a lot of interesting questions. Is the lawyer the client of the mediator? Is the lawyer advancing the client's best interests by getting in the way, so to speak? Is that maybe something that's been scripted in advance? How do you, as commercial mediators, when you think the lawyer is getting in the way, do you talk around the lawyer? Do you talk to the client alone? How do you deal with that? Dan?
Well, I just want to first acknowledge that it's very tempting to be more concerned about the lawyer than I am about the client, because I see the lawyer as a potential source of future referrals. I'm aware of that pressure. I have to refer back to my principles, though, that the clients are the clients. At the same time, the lawyers are participants in the conversation. So for me, it's about having everybody have the chance to say what they need to say to each other. I liked Helen's point that mediating between a lawyer and his or her own client is a common phenomenon, helping them understand each other, because it is kind of rare that they're both on exactly the same page.
Yeah.
So for me, it's just sticking with that principle of facilitating the conversation, helping everybody say what they need to say, which is the thing that's most likely to help them get to a different place.
Yeah. How about you, Helen?
Yeah.
I've seen you do it. I mean, I've seen you say it in front of the lawyer. Yeah, just a minute. I want to hear it.
Well, yeah.
Right?
Well, yeah, they don't like that either.
No, I know.
They don't, but I'm short. I can get by with it.
I do it too. I do it too. They get pretty pissed when
Yeah.
No, I asked your client.
Yeah.
Yeah. I use my preschool education and I say, well, I know you have something to say, but I want to hear from your client. Yeah. So that's sort of the way I say it. But I think that everybody that is in that room has a different interest. Remember when we took our mediation course and we talked about interests over positions? Everybody has a different interest. The lawyers have a different interest than the clients. And so sometimes what I'll do is I'll say, I need to have a lawyer meeting. So, and then I'll pull the lawyer out, and I might not even go get the other lawyer, really. And really, I have to tell you my favorite line. One time years ago, I was doing this mediation client. So everybody has a different interest, and I think as mediators, we have to be attentive to that. And it is scary sometimes. I mean, you think you're going in there and, oh my God, these attorneys, they practice in this area of law and they know so much more about it. But you know what? It's about human nature. And it's about what people want, not what they need. And when I do employment cases, I'll give y'all my little tip. I have the offended employee write a letter that she wishes she would get or he wishes he would get from his employer, and I never see it and they never see it. And it is about the most therapeutic thing that can ever happen. I don't know how it happens, but they just write this letter of apology that they wish they could get. And nobody ever sees it. And they're like, oh, wow, that felt great. Okay, now let's go on. And then they're ready to negotiate. So, I mean, I do all kinds of little things I did in preschool probably, but it's not stuff you didn't do with your children or your animals. And so, we just have to get outside of that, this is my mediation and I'm going to get it settled. That's not what it's about. And God, John, I mean, I agree. I do mediations that last 6 months. I mean, I get invited to their weddings, for God's sake. I mean, it's like, because when I'm doing sex abuse cases, we have the first mediation, And those might be coming out of a bankruptcy action still, but I gotta tell you, I got a victim there. And then I've got all these, we've got all these confidential blah that we have to put in there, and it won't go to the paper for 2 years, and I mean, everybody, the victim has a right to do this and that, and we've got to tolerate that stuff. So we do. So, and I think it's a matter of us getting our egos out of it and really saying what we mean, that we are facilitating a process and that we are helping people to get to their own resolution. That's what it's about.
Judge Borg, I was going to ask you because my experience when you've mediated is a little bit different. You actually take the lawyers out of play by putting front and center. You take a lawyer out of the room, you go outside for a break, you have a conversation.
That's when I was smoking.
Yeah. I used to actually go out and buy a pack of cigarettes so he'd take me and not the other guy.
Because I was a bummer, it was always a way to get somebody, if there was somebody else who smoked, they'd say, any smokers here? And invariably they have one, and they go, well, let's go, we got to go have a break. And so you get some one-on-one with clients, one-on-one with lawyers. But I do what Helen does. I kind of call them out, and I don't want to talk to the other lawyer, I want to talk to this lawyer. In a perfect world, I would have a 15-minute phone call with every lawyer in every case a couple of days before we get there. Because you will tell me things that you can't tell me in front of the client, don't want to tell me in front of the client, God knows, shouldn't tell me in front of the client, because you're going to tell me about the client. And you can't tell that to your client's face. Some lawyers do. Some are able to get away with it. But that perfect world is pretty hard to manage into my life as well as yours. So here, let me shift it a little bit. I think you ought to feel free, and I do get these calls occasionally. I think you ought to feel free to call the mediator. I mean, you get to have a lot of ex parte stuff under the rules for mediation. Everybody doesn't have to be under the tent. They don't even have to know you're talking to them. But if you think you've got something that would help the mediator understand the setting in which you find yourself, I think you should take the initiative to call me. I promise you they'll call you back because they want to know what it is you got to tell them. And it helps us understand and begin to blueprint and kind of map out the strategy to move the parties together. I think that's a huge deal, and I think you can take the initiative to do that. I welcome those calls. I find them without exception to be helpful. Typically, it's rare that the lawyer really doesn't want to settle it. I mean, it's rare. Usually they feel compelled to argue the client's cause because they think that's what they've got to do. I mean, there are a gazillion reasons that they'll give you signals at the mediation that they don't want to settle it. But boy, I get them alone and they go, no, you gotta make this go away. We've got to figure out a way to get this done. And I go, well, then what the hell are you doing? Well, geez, he thinks I ought to blah, 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 blah. So then we sort of strategize, how do we sort through that? And how do we kind of work around it? And now we're working on we're going in the same direction, and it really moves things along. But I don't know, do you get to talk to the lawyers before?
I call them before.
Yeah, but every case?
No. I
have such a hard time getting a hold of them.
I know.
I found something to fight about with you guys here.
Okay.
So, my concern about these ex
Why
parte
do you want to
calls.
fight is what I want to know.
Because it's more fun. Well,
He doesn't get to do it in mediations.
Go ahead.
I don't know why. My concern about those calls, and by the way, I'm also open to receiving calls and hearing whatever lawyers want to tell me, but my concern about what can happen with those is that, again, I feel the temptation myself to feel like I'm working for the lawyers. And if I hear from a lawyer that, well, listen, my client's a little unreasonable on this issue, they have exaggerated hopes about that they can prove the breach of contract or whatever, and he doesn't believe me, you got to tell him. I might be tempted to get on that lawyer's side and work on his client with them. And that, for me, that's a betrayal of my client there. To me, it's in order to keep my process as potentially helpful as I hope it to be, it's got to be about me without any hidden agendas from anybody. And me consistently supporting the conversation, which hopefully helps this lawyer, for example, figure out how to say to his own client whatever it is that he's having trouble saying.
Right. Yeah.
So I'm just concerned. And I guess again, it's not. I'm probably hearing stories about mediators other than you two, but I'm hearing.
Oh, you're probably hearing them about us.
But I hear of parties that experience mediation as often kind of just as bad as the rest of litigation. It was something that their lawyers took them to, it's something that their lawyers controlled, and then the mediator controlled everybody. And it's not this empowering thing about self-determination that it could be, I'm afraid, out there. I mean, let me ask you guys, do you hear stories about other mediators that seem to you like they're being a little bit too manipulative of the clients?
Yeah, I mean, I get calls from people that want to complain about somebody. Yeah, you do. But what I was just thinking when I was looking around the room is I was thinking, I think there are 4,000 people on the neutral roster. And there are only about, how many people are in here? 80 maybe? So I'm giving the responsibility to you guys to you seem more evolved. You got here. And so I think that you all are human beings and can act like human beings. And that's probably why you're here, to get reinforced, really, when you really think about it. So, I think that as we go through this process, even if it's some boring little case, really, that we would consider to be boring because it's a, commercial matter, they always have a little interesting tweak, and I think we need to get to that. I think it's kind of fun. I mean, I think everybody's telling a story. I love that part. And, it shocks me sometimes what the results are in those mediations, really, with some of the settlements. I mean, they're pretty fun. Yeah. And they're a lot more creative than we could ever be. And we're just facilitating the Thanksgiving dinner, really.
Oh, man, every day you think you've seen it all. You go do another one and you go, holy buckets. Where did that come from? Never saw that coming.
So, but Dan, would you prefer if a lawyer were to call you and say, I want to talk to you about what's coming up or what we just did yesterday, do you find yourself saying, well, do you mind if we just get away on the phone and let's all talk about what we did yesterday?
I actually wouldn't make that precise move. I would assume that the lawyer is calling me because the lawyer is trying to figure out what to do next. Mm-hmm. And so in order to be as supportive as possible of that lawyer, I'd hear him say, whatever. I would say, okay, so you're saying whatever. And then he says, well, yeah, and maybe can you help out by doing that other thing? And I say, well, my way of helping is to facilitate the conversation, so by all means, if you want me there when you talk to either your own client or the other lawyer or whoever it is you're strategizing about, would love to help you have that conversation. Sounds like you're concerned about having that conversation yourself. Anyway, I do my thing where I counsel them toward figuring out what they need to do, but I'd avoid taking any extra responsibility from them.
Oh, right.
Yeah,
I think you're saying that too, though.
Yeah,
I mean,
okay.
Yeah.
Okay.
Howard, what do you do?
I have a philosophy that if it wasn't for the fact that you've got two individuals that have some real strong feelings, the two attorneys wouldn't need us as mediators and we'd be unemployed.
Yes.
So I see my role, if I get that phone call, I don't want to get that phone call and say, I need your help, they're unrealistic, and then that attorney's fighting me in there to be here to his client. I said, if you want my help, you have to go with me.
Yeah.
I'm not known as someone who beats up on people.
Right.
But yesterday I had one that I was told, unless you beat up on the husband, this is never going to settle. Well, I did it, and I did it gently, but we have to be on the same page. And so I think that I'd say over half my mediation is because of lack of client control or the unwillingness of a client to hear from their attorney what the case is really worth.
Right.
Because if I tell them, they're going to go to another attorney. They would rather have the mediator play the role of the bad guy and say, hey, this is all that's going to happen. And then the client leaves and they're satisfied. You can tell them about the other 100 cases you've done, and they're satisfied. So that's a little bit different of how I view my role. And so it's not me against the attorney. It's me helping the attorney communicate to their client. Now, not both may need it, but when they need it, it's why the case isn't settling.
Right. Yeah.
Well, so I just want to observe about that comment that getting the case settled is the goal, and that's kind of the rationale behind your approach.
No, from the client. Getting the
case in a position where the parties can settle if they want to.
Right.
You can't get in there without, there's a lot of listening on my part, a lot of communication. There's someone, I do mostly personal injury. There's someone who may have a neck injury and a back injury with no objective findings, and they heard about Uncle Harry, they got $250,000, not knowing there was a 2-level cervical fusion. All right, and that's what they come in expecting. Well, they need to be educated about the different types of values and how they're evaluated. And so education is a very big aspect of it.
And am I right to understand that the education is going to come from the defense lawyer and the defendant, right? I mean, you're going to facilitate.
They'll be in separate rooms. No.
Okay, now what's going on with that? They're in separate rooms.
I've been doing this for 17 years, and until the case is done, if they want to meet each other and shake their hands, fine. They never even know they're there. They don't see each other.
I'll tell you why, though. I can give it to you. 'Cause- and the reason I think that is because they're talking two different languages. And if you sit there in front of a defense attorney and say, tell us your upsides, it's going to be like an opening statement. And the plaintiff who's injured is going to be pissed off. And there's just no, well, not in a bad way. They're going to be saying, they don't like me. And by God, I'm going to show them. And, the truth of the matter is, they don't get to hear what their attorneys say then. And so, for us, when we do PI, if I find out they haven't met anybody, if they haven't, met the other side, I have them meet them and just say, hey, how's it going, that kind of stuff. But I don't ask for opening statements because it can exaggerate it. I don't like opening statements. And so, and that's me personally. I'm doing that for me, not for anybody else. The attorneys don't. And so wouldn't like that to happen in front of a plaintiff, really. I just think that they're talking such different languages. They're not saying to the plaintiff, so sorry you were injured, hope we can get this resolved. I used to have them do that. They're just saying to the plaintiff, here are our upsides, soft tissue. And I tell them those things. I go back in and tell them those things. Really why I don't do it is because a lot of the defense people don't have good people skills. Really, is why.
Well, but in a commercial context, though,
yeah.
sometimes you have sophisticated business people who spend a lot of time doing those kinds of communications.
And they stay together.
Yeah.
Here's the thing that I suspect that even the most experienced mediators here haven't experienced. You haven't been in a situation where you were facilitating the conversation between, let's say, the personal injury plaintiff and the insurance adjuster, where both parties knew that the mediator had absolutely no preference, where they really experienced that the mediator had no preference for either of them compromising. In fact, they experienced that when whatever they say gets reflected and not judged by the mediator, their people skills improve. I mean, for me, the beauty of this mediation thing is that people can even, and I hear you, not everybody has, people vary on their skill levels, but for me, my belief is that humans, when they're talking to a human who was injured somehow, are able to say something meaningful and kind of more meaningful than anything I could say about their conflict. So I understand that in the context of mediation as it's been conducted, where you guys aren't saying so, but I feel like other mediators base their success on base their kind of egos on how successful they are at getting deals done. In the context of that sort of process, yes, the adversarialness between the parties is going to remain pretty escalated. The trick is to provide a process where people have the epiphany that, okay, wow, the real person calling the shots is me and this other person that I'm looking at. And so people just getting a little consciousness raising about, okay, this is up to us. I don't think that happens in these mediations where people are kept separate or where we are attached to the idea of at least getting them to a place where they can settle. Even trying to get them to a place where they can settle, for me, is us taking control.
You mean the participants taking control?
If the mediator believes if I believe that
orchestrating.
my role is to get people to a place where they can settle, that's me calling the shots more than...
Yes, I agree with you. Yeah, with that, yeah. You had a question.
It seems to come down to why you're hired, maybe also by who you're hired, but I think, Dan, what you're saying, we've had many discussions, that you're hired maybe for a different reason, or you provide a different service than another mediator, and maybe the participants want a certain style, and what they're buying, or is what's at issue.
My concern is that we've made the assumption, many of us mediators have made the assumption, that we're being hired to settle the case. And I know that parties and lawyers say, hey, we want to get this settled. That's why we're going to mediation. We don't want to go to trial. That's part of it. But they also say a lot of other things. They say, that other side is full of it, and they think they can extort money out of us. And they say, I'm not sure if I did anything wrong here. Maybe I shouldn't have done that one thing. There's a more nuanced list of desires that they have, and I'm claiming that mediation can help with the full breadth of their concerns, including, to the extent they want to settle the case, they can talk about settling the case. I'll be right there with them on that. And to the extent that is what they come in looking for, by all means, we'll support that. But I don't think that's the only thing they're looking for.
Yeah, I mean,
You with me?
yeah, yeah. Me
Well, sometimes they don't know what they're looking for.
neither, that's it.
They're confused about it, for sure.
Yeah.
Somebody's question?
This may be a little bit abstract, but it strikes me there's a bit of a dilemma or a bit of a tension here. On the one hand, we're talking about mediation, which according to Rule 114 is a process based on self-determination.
Yeah.
And in the same sentence, we're talking about client control. So how do you put those two together?
Because you do.
Well,
I mean, the judges want you to do it, and they're the ones who are the ultimate engineers of
That's
where
right.
these cases go. And that's simply the conflict in the process. I mean, lawsuits are cast as winners, losers. They're adversarial by definition. They're adversarial by their nature. They're adversarial by the parties who are engaged in them, typically. Well, and then we're going to go all make love and peace and mediate. Are you shitting me? I mean, we got to climb that fence in the first place. And when we're talking about client control, that's in the eye of the beholder. There are a lot of lawyers that really believe that means exactly what it says, and that is that the client does what I tell him to do. And I do, as you probably do, see lawyers half the time where the client looks at them and says, tell me what to do.
Yeah.
Well, who wants that? I mean, you got to drag these folks down the tunnel with you because they got to buy into it. So you've got a lasting, durable peace at the end of the day. So yeah, it's just another one of those crazy conflicts in the law.
I get not to engage too much in it, but
No, feel free.
I don't mean this in terms of setting up a contentious piece, but I think what you're describing is a reality. Here we have a court rule that is either a myth, and let's be honest and call it a myth and do away with the language, or it means something, in which case we have an obligation to try and move in some direction that honors that.
Yeah,
and I don't think there's a right or wrong answer, but I think it's a struggle that we have to engage in.
No, and I would agree with that. And when I think of client control by the lawyer, to me it's about managing expectations on the part of the lawyer. I mean, we run into lawyers that really do control the process and the client. We run into lawyers that hands off. I got nothing to do with this process, have at it, and you get everything in between. And one of the exercises or drills that I wind up going through, and I'm sure you two do as well, what are people's expectations? Not just of ultimate outcome and what's doable and what you can achieve, but what are the expectations of process? And not just process in a mediation, but process if you don't solve it, what's going to happen. And most people have not been down that road as a client. And if they have been, if they're sophisticated litigants, because by virtue of their business or whatever it is they do, that they're well seasoned in litigation, you don't have to school those folks much. But it's understanding what people understand it to be and then working your way through that without standing there telling them, well, let me tell you how it is. Because we can't do it that way either. We sort of got to, have them, you kind of got to drag them down the tunnel a little bit with you and go through all of that. Now, I run into a lot of lawyers, and you all do too, who, let's get right to it. I go, we can do that. And this can be over and done, and you'll be out of here for lunch. Not a problem. Happy to do it if that's the way you want to do it. But we need to negotiate the expectations on both sides of the table, because if you've got one side that is going to engage in this process as long as it takes, and you got the other one who's got to be over and done with it by noon, and here's our bottom line, and we ain't talking any more than that, well, either you disarm that and you negotiate the shape of the table, for those of you that were alive during the Vietnam War. Sometimes you do have to negotiate the shape of the table. We do it all the time. All the time. Okay, what are the rules? What are we going to be? You don't use the rule word, but that's what you engage in to see if we can't get everybody not in the same room, but in the same room.
You had a question over there.
Yeah, we had quite a bit of talk about potential issues between attorneys and their clients. I'm wondering, as part of your dog and pony show at the commencement of the mediation,
you kind of address it. You ask permission to maybe have an attorney timeout, to meet separately with the attorney, or to meet separately with that client. Or maybe to have a discussion between the two of them on resolving issue. In other words, you seek authority to be able to say, we need a timeout. I need to talk to just the attorney or just the client. And if you don't do that, you say, I need to talk with the client alone, and then the attorney says no, what do you do? How do you handle that?
Very rarely, I don't really, like, I'm not gonna take the client by themselves unless the attorney say, hell no, we don't wanna go in with them. But, I'll talk to the attorneys, I won't talk to the clients by themselves where they're represented. They have attorneys with them. But I will lay it out, I mean, I'll say to them, this is a pretty fluid process when I have everybody together, when we're signing the agreement to mediate. And I'll say, you know, there might be a time where I wanna take the attorneys out and have an attorney meeting. And, you know, it's just because we have to talk technical stuff, no big deal, and I'll let you know when that's gonna happen. I mean, I just let them know that it's kind of, I'm going on my gut more than anything else. There's no real recipe for this, because some mediations take a half a day and some mediations take 5 days. It just depends. But I'll kind of lay out the ground, what it might look like, and let them know that we're gonna be flexible here, and I'm gonna kind of go with my gut. But I won't take the clients alone unless they come unrepresented. They're not going alone.
I'd like to get back to this discussion of client control a little bit. To me, that terminology, and I understand that we don't mean it as harsh as it sounds, but
Well, some of us do.
to me, that concept makes a lot of sense in the legal world, where the lawyer is the expert on the process and is doing the client a favor by advising the client how to proceed through a trial or an arbitration. The thing that I'm attached to mediation providing that is different is client control in the opposite sense, that clients control, that it's possible to provide a process where they are completely in charge of how it goes, and they get support for that. One of my assumptions, and this is kind of gets to what Patrick asked about what are people looking for when they seek a mediator. My generalization, and I don't know if it's true, but I think it is, my generalization about what inspires people to come see a mediator is kind of, as you suggested, John, that they don't know what to do. They got mixed feelings. They've got this moral dilemma. Do I fight to the death on this thing? Do I cave in? Neither of those sounds very good. Do I offer something right now, or is it too early to make a concession? Do I tell that guy what I really think of him, how he cheated and lied, and I thought we were going to be friends, but he is costing me $500,000 with this lie he told me? What do? I think they're in a world of uncertainty. And I think that what we can provide as mediators is an opportunity for them to get clearer about what does matter to them. And also, given that the other side is probably in a similar world of confusion, we can help that side do it as well. And then we can help them clear up their confusion about just how evil the other side is, because they seem a little bit evil if you're suing them or being sued by them. They may be a little bit evil, but probably you could probably have a better understanding of exactly where they're coming from with a good conversation. So I think we're talking about really actually fundamentally different ideas of what the purpose of mediation is, I think. Yeah.
Well, I don't know that, go ahead.
I was gonna ask you a question. So, what I wanna know is, what happens if you have a mediation and you know how you run your mediations? And the client said, no, I do not wanna be in the room with that employer.
Yeah.
So what do you say?
Rule number one is that they call the shots. So absolutely. I do share with them, in the interest of transparency, that I see mediation as being about a conversation.
Right. Yeah.
And to the extent they don't want to have a face-to-face conversation, by all means, they don't have to. I'm actually in a little dilemma about my practice currently. I talked to a colleague who is committed to the idea that she will not carry messages from one side to the other. And given my sense of how communication works, I like that principle of hers, that, if they're in separate rooms, their choice.
Sure.
But if they want to get a message to each other, it's not my role to be the conveyor of it. If you want to send your lawyer over there, there's other ways to get around that. But yeah, no, the party choice is the first.
Okay.
But my experience is that you know, and again, I've had just a handful of significant commercial cases. My experience in those was that people wanted to talk to each other. In fact, that, dude, why are you suing me? You know, is a
Right.
basic question the defendant has.
Yeah.
There's a couple questions, I think, here.
One of the main problems that I encounter is what I call the empty chair syndrome. We don't have the right people in the chairs. Sometimes the chairs are all full, but they're full of the wrong people.
You are so singing to the choir.
And it's more common in commercial arbitrations than it is a personal injury case, and the plaintiff is going to be there. You've probably got the wrong person from the defendant's insurance company there. And
You always have the wrong one.
And you don't have the defendant there, and you always don't have the defendant there, almost. And sometimes the defendant has got a stake in the thing. But this is a problem of preparation, I think, and trying to figure out who are the right people to fill the chairs and making some effort to avoid a situation where you've got outside counsel that doesn't really know very much about the technical problem that brought about this dispute, and you've got a loss prevention representative of the company, and you might have the wrong insurance person there, and you probably need somebody from production there, or somebody that had something to do with the process. I'd be interested in thoughts about how to do a better job than I've been able to do about filling the empty chair.
Well, boy, we could have this conversation for a long time. I think we all come out at the same place. It kind of is what it is. You know, none of us have the power to require the appearance of anybody in particular. The best authority for that, of course, is if you can have the court that orders the mediation or the alternative dispute, whatever it is, order that. But from a practical standpoint, and in fact, I used to order it that way. I said you had to have somebody, but that was in the olden days. I mean, I would left the bench in 90. And in those days, you actually could get somebody who had some authority. Part of the drill for us to find out early on is where does the seat of power and authority reside? Yeah. And does it sit before us, and are there limits on all of that? And then we deal with what we know we have. Doesn't make it easy, but there's no way to require an insurance company to send in their reserve, their committee, you know, that does who sets their reserves. It isn't going to happen. It's never going to happen. And I think we just work with that. We live with it. We understand that's the deal. And the thing is, you kind of got to out them without them knowing you're outing them. Because they'll tell you, oh, no, I have all the authority in the world. Well, the hell you do. You know, they sent you in with $100,000. You got policy limits of $2 million. We know you, that's all you got. But you can't do that because then they stop talking to you and the mediation's over. So if I can get them on the phone, and if they've got access to the people who have the authority, I can work with that. It's not optimal because they come in and they do by remote control. You know, they got the clicker in their hand in Chicago, and they say yes or no. They're not part of the conversation or anything else. So what am I'm not telling you anything helpful here. All I'm doing is helping you define what you've already defined.
Isn't it almost always a mistake to go into the mediation, a commercial mediation with a substantial dispute, substantial amount of money involved, without having done some pre-mediation work?
Well, you might do that during the first mediation. Yes, I agree with you that, yeah, there should be some pre-mediation work. But I have no problem rescheduling a second mediation and saying, no, I'm having everybody here. I don't care. I don't have any problem with that. And so, and really, when I have somebody that's on the phone, I just did it the other day. I said to the claims person, hey, I let you stay home. I need more money. You know, really, come on. I mean, I can beg. I don't care.
Oh, I don't either. I'll beg, sure.
Yeah. I mean, so, you know.
Except I won't give them any of my fee when they say, well, you kick some in. I won't do that.
No, hell no.
There's a question in the back here.
So I think that you schedule a second mediation. That'll make them settle. The other thing is, remember, the mediation doesn't end that day. It keeps going. Everyone, and Sylvia had one over there, too. But.
Yeah, there's one back here, and then we'll come over here.
That mediation ended about 5 minutes after it started. We were there all day. I'd love to hear your thoughts on the imbalance of the personality disorder with a lot of power on one side and the different personalities on the other side.
So to the extent that it's true that those personality disorders exist, my greatest contribution, if any, is for the other parties to become as clear as they can about the reality of who they're dealing with.
They got it right away.
Well, why did they stay all day? How did that happen?
Because I kept saying, we've paid for the first day already, we've already done a lot of work on this subject, you've got a long flight home.
Yeah.
I just kept trying to see in different ways. They would not meet separately.
Yeah, I of course wouldn't diagnose anybody myself, and I would assume, for me actually, Bill Eddy's list of characteristics of the high conflict personality, to me that is a human being in conflict.
Really. Yeah.
And so, you know, I hear you, I believe that this person was an extreme case, but I would always assume that this extreme person will be a little bit easier to deal with if they know they're being heard and understood, and I hear you, it doesn't necessarily work, but.
He was a surgeon who was convinced that the next step was going to be arbitration, where he was going to represent himself there, and beyond that, even if he got an adverse ruling, he was going to go to court, appeal, and represent himself there.
I don't want to get into
Was he
it.
Imagine in commercial mediations, you have more sophisticated and perhaps equal bargaining power, if you will. But in my experience, almost every mediation, one of the most vital things is information. And oftentimes, the client is the least sophisticated, doesn't understand the process, and can't make a decision until they go through the process. And what I was curious about is, oftentimes they see the mediator as an extension of their attorney or as an expert. And I think they look to you for information so that they can then have some power to make a decision. And do you feel that it's okay to give them, whether you call it advice or guidance, if you give them information so they can become informed?
I'll give them information. I won't give them advice. I won't give them guidance. I'll talk about the different ways you can approach or respond to what the other side has said that they want. You know, you're really right. And there are cases that are where you have both the lawyer and the client, neither of whom is very decisive or who are afraid to make the decision. You know, it's all part of this, all the preliminary stuff. And I know a lot of people think, oh my God, we're spending so much time on the preliminary stuff. But you got to know who you're dealing with. And when you get that double whammy of a lawyer and a client that is so indecisive, they just can't get there. There are people in this world who want somebody else to make every decision. And they'll let you do it. And they'll say to me, well, what should we do? Do you think we should take, I can't tell you that. You know, and you can't do the work for the lawyer either. Those are very difficult. All I can do is agree with you. They're tough situations, and they take a long time.
This is where it comes in handy that I'm not an expert. My lack of experience with litigating these cases gets me off the hook easy and gets me back to what I'm hoping to provide, which is them to get the information that I assume is most important, maybe from their own lawyer, maybe from the other side. It's not information I have.
So, you know, when you send me in there and say, go bond with them, Helen, I really do. And I'm not telling them a damn thing about what to do. But I am bonding with them. And we are getting to know each other, really. And then I'm saying to the attorney, now, tell me what happens if we don't settle this today. And not even that. I'm saying, first of all, to the person, tell me what happened to you. And then they talk about what happened. And I say, well, did you sleep? Could you, did they get out and say they were sorry? I want to know all the personal stuff about what one would expect if they were in a bad accident. And go ahead.
No.
And so then I'll do that. But really, Sylvia, I never, ever tell them what to do as a mediator. I'm always saying to the attorney, the only thing I do is ask the questions that would be on the jury verdict form.
But sometimes I find that they seem to doubt their attorney. So they look to the mediator kind of like, is this for real? Has this guy been telling me the truth?
Yeah. Well, when I say to the attorney, that's a possibility.
Well, and sometimes you want to know where they are in the food chain of process, the client. Some may see this as the moment. This is as good as a trial. And that's why they'll sometimes look to the mediator to tell me what's fair, what should be the outcome. And you go, well, that's another day.
Right.
And as another friend of mine says, I can defend you to your last dime. That's downstream, that's Bill Skolnick. I gotta give attribution where it belongs. But I do have a comment. I do a lot of commercial disputes, and I do a lot of minority shareholder fights. And I do some with the giants where it's actually a fair fight. I mean, where you got Medtronic and St. Jude going at it, or you got some big dogs, and I mean this is donut money for a month. But in a lot of the smaller companies, and they might even have really good revenue. I mean, I do some with companies with a couple $100 million in revenue, and it seems like a lot of money, but it depends on margins, profitability, blah, 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 blah. But when you get into the fights where you got 2 or 3 partners and minority shareholder disputes, those are not fair fights. They're rarely fair fights. You have a balance of power in those relationships that you can usually figure out pretty quickly, early on in the mediation. It is necessary to figure that out, though, because you'll usually have a bully, and you'll usually have somebody who hates the conflict, and it's weird how they become partners, but they do, and they've been partners for 20 years, and now it all falls to hell, and we can crawl behind all of that and try and sort it all out, but it doesn't resolve it. What we need to understand is that we've got a mismatch in the balance of power, and one has more power, has more resources, has more determination, has more drive, more damn the torpedoes, I don't care if it destroys us both kind of stuff. And the other one is, what do I do? What do I do? What do I do? How do I be done with this?
So do you draw that out during the process? Do you try to get these people to acknowledge that's where they are?
Yeah, you got to get that. And sometimes they need to acknowledge that to be able to get over the hump and get themselves into a position to resolve the case. Sometimes that doesn't help. I mean, there are people who say, I don't care. Just get me out of this.
So Dan, doesn't that sort of suggest your transformative process that kind of helps to balance that out a little bit?
Well, it sounds like you're hoping for the same thing I'm hoping to allow for, which is the victims of the world to stand up and take good care of themselves, and the bullies of the world to get in touch with a little bit of their compassion. Or you say that's not what you're saying exactly.
No, I'm not just. No. I was shaking my head. Bullies are bullies. They started out being bullies in first grade, and they ain't going to stop until you throw dirt on their box. And that's the way they're made. That's their DNA, and it'll always be like that. And and the one that doesn't want to push back, same thing.
John, can I ask you a question about the big dogs? So you've got the ones that you're not worried about a power imbalance, and you're not worried, I assume, about educating them too much. But somehow these sophisticated people have gotten to a point where they're litigating. And, I assume that they're mostly concerned about the bottom line and doing as well as they can.
That's all they're concerned about.
So something's going wrong in that because they're wasting money on lawyers currently. Somehow there's something not optimal happening in their negotiation because it's costing a lot. This is where, I'll tell you what my assumption about what's going on there is that there is something about the communication which is causing those people to be a little bit more defensive with respect to each other, a little bit more demonizing of how purely bottom line oriented the other side is with not even a heart whatsoever, whereas at least we're St. Jude, we care. They have some sense that there's something about the interaction between them that is messed up. And so when I hear that story, I think, okay, perfect. I've got the antidote. I'm going to help those people talk directly to each other and experience that they aren't quite as evil as they seemed when they first served the complaint.
Oh, I see what you're saying. Let me just, of course, if you see that, let me tell you about the mediation I did one time. Come on, if they're going to have an ongoing relationship, the problem that we have is we know this now because litigation has taken on ADR, is that many people don't have a continuing relationship anymore. They will never see each other again. They don't care if they never talk to each other. Right. Now, in those commercial issues, they're going to deal with each other again. So it's like they're going to always do business together. So that's a different kind of thing, a different kind of puppy, if you will, as opposed to some of the cases that Sylvia's talking about and some of you are talking about that are personal injury cases where they're never going to see each other again. They don't care if they ever see each other again. They really don't.
They say they don't want to see each other again.
Well, that would be in employment cases where somebody's been fired. They don't want to be there. And they don't want to be on the same floor, by the way, pay attention, if there's an allegation of a sexual assault. Do you understand me? Never on the same floor. And I'm good with that because that's their process. And they're saying, we ain't doing it. And so, and I'm not going to throw a victim in a room with a perp, ever.
Even if she requests.
Oh, if she requests it, hell yes, she can do it. But if she says no, or he says no, it's not happening. No. And you have to pay attention to those things. It's not a business deal. It's a personality deal.
It's an institutional personality.
It is.
Which is real interesting.
Yeah.
You know, how does that get created? That's like Frankenstein. You put parts and pieces together and you come up with this monster. And I don't mean monster bad, but it is. It is a conglomeration of significant personalities, executive officers in the company. And, you know, what's really fun to watch is the evolution of a company as it gets larger and as it becomes, you know, worth more and all of that stuff. And as you see the senior leadership change, you can see a change in the personality of the entity and how they approach things. It is absolutely fascinating to see that. But you need to understand that when you're doing cases with the big dogs, because it's all about the money, it's all about competition, it's all about market share, and it's all about revenue tomorrow. And that's the only thing that drives it. I don't need to understand the other side. I want to know how much money they got. And make no mistake, it is about how much money they got and what can I do to them tomorrow in the marketplace. They're tough to resolve because they all got the money for the fight.
Questions? Go ahead.
Observation. Having done a lot of work in corporate other than mediation, and also being a student of the science of human development, what we are missing is some way to assess the level of development of an entity, which it can be done, and the individual. Now when you've got employee that's been trashed and corporate monster, it's real hard. But we don't see that difference so much in family mediations because people sort themselves out according to their development. And we're missing that piece in commercial. Does that make sense?
Yeah, it does make sense. I don't think we're miracle workers and can take care of that in a mediation.
No.
But I think, I am one of those people that will say to somebody in a corporate thing, well, how the hell did y'all ever get together in the first place? I mean, I will say that. You know, it's like, whoa, doggy. You know, usually it's the artist and the scientist, and they decided to get together and start a business, whatever. And so I'm thinking, oh my Lord, and you survived for 20 years?
Yeah.
Wow, amazing.
Yeah, it's
fascinating. And what did you do with all that? So I mean, and I don't mind saying to somebody, you know, like, well, you're at this place and you're at this place, and that's where you're going to stay. The only thing we can do, nobody's going to change. I always tell people this. Nobody is going to find God in the mediation room.
Right.
Never. And there's not going to be a trust fall or a love hug at the end of this mother. Really. And so what we're here to do is to see if you guys can put it in your, take it back and figure out a way to settle this. That's really what I tell them. I want to give it all the way back to them.
Helen, how do you know there's not going to be a hug?
There are hugs with me all the time.
Well, that's not fair. You get all the hugs.
No, well, I mean, I don't want them to go in with any unrealistic expectations, and if they decide to do that, all the more power to them.
I'm afraid you might be setting their expectations when you tell them there's going to be no
All right,
hugs.
I'll watch it next time.
Yeah.
Okay. But anyway, I tell them. But what I think that we need to pay attention to is that, yeah, they may be like this, and for me, it's perfectly fine in the same room to say, here's where you are. Now, you guys got to figure out, it's my version of dying with dignity. Now that you know where you are, how are you going to figure out how to get out of this or stay in it? That's what you have to acknowledge.
Well, when you say you know where you are, I mean, one of the most common themes we hear in mediations from mediators is, you know, this can be over today for a certain sum of money, or you got the uncertainty and the cost, the price to get to the uncertain result. And so one of the questions that comes up is, how much do you emphasize the uncertainty and the cost and the fear that goes along with that, as opposed to emphasizing, look what you could have. Look how you could get it done. You know, deal or no deal.
I really think that's subject to their interpretation, what they think they could have. So I'm not big on trying to sell it to them, because just because I know somebody tries to sell me something, I know that there's some missing piece. And so so I'm not very big on that part. I will say, you know, now, here's where you are, and you have to figure, what we're going to do is see if there's any way to both maintain your integrity, really, and then to see if we can still cut a deal so that both of you walk out of here feeling like you're equally dissatisfied. I can say that too. I do say that. And so anyway, and sometimes they'll look at each other and say, "Are you as dissatisfied as I am?" And the other one will say, "Yeah, I am." And and so, you know, I'm okay with that. But so those are just my terms of art, and I don't think everybody should use them. You know, really, I'm telling you what, you know what, when you eat alligator in 8th grade, you can say anything. And so I you know, I don't know if I can get by with this in Louisiana, but I can get by with it up here. And so when I'm talking like that to people, my whole deal is we're not going to change the past. All you can change is the future, and that's what you have to figure out if you want to do. And if you don't want to do it, it's not my fight. I don't care. So they can talk to their attorney about how much is this going to cost going forward. I'll ask the questions. I will say, do you care to entertain that? If they say, yeah, I'm there with it, you know, I'm fine with that.
Okay.
And then I'll do math with them. I'll say, okay, let's say you won. And now, you won it. Now, what's the chance of this going up on appeal? Okay, well, maybe you win it in 3 years, whatever, 5 years, you know. So we'll talk about that kind of stuff. And I'll do it in a very informal way. And so then we'll talk about what actually ends up in the pocket of whoever we're talking about. And that's pretty mind-boggling sometimes.
Yeah.
And so, you know, they get to decide. I don't say, do you think it's worth it? I don't care. I just want them to figure it out. So I just want to answer the questions for them.
But Dan, you do it differently, I think, don't you?
Yeah, yeah. My sense is that what you're saying is pretty prevalent out there. That the mediator does see it as helpful to at least ask the questions about how much it's going to cost.
But you let them just lead, don't you? I mean, you let them. Your participants just ask the questions.
That's right, and I don't answer them. And so my approach would be to, and my concern about that prevalent practice of emphasizing the downside of going forward is that, first of all, I don't think it's probably too effective because the parties know that you're trying to sell them something, sell them on a compromise. Right. So they know that you're overemphasizing the weaknesses of their case. And it's just not the truth to the extent that you're giving them information about the downside. Mediators do tend to neglect the upside. And so in terms of a process where they are making the best possible decisions based on real information, I don't want my clients to be exposed to a guy who's pushing in a certain direction.
Right, I don't
so,
either.
Yeah.
So Dan, would you be more satisfied with a mediation that ends without a settlement, with both sides walking out saying, I heard and now understand who that person is?
Mm-hmm. My way of evaluating a session is whether I remained kind of consistently true to my intention to support the conversation. And I don't know where it's going to end up ever. And settlements are wonderful, and feeling like they were understood is wonderful, but it's really up to them what they're going to get out of the conversation. So it's up to them to evaluate whether they got someplace better or not, as I see it.
Okay. You know, we do cases where what you just said has got to be something one side gets. I mean, they got to have that to be able to resolve the case. My experience is not every case is like that. There are plenty of them that are, and I think then as a mediator, I try and get that delivered somehow. Get that into the equation, because if it's that scratch that's got to be itched, you know. I mean, part of the deal is, what do you got to have here? What do you got to have here to resolve this? And sometimes people have a hard time describing all of it. But I hear frequently what you're saying. You know, I want to be heard. I want them to know how I feel about it. I need, you know, the sort of the cathartic part of it is an essential piece of the resolution. And then you got to be creative about how you get that delivered. You know, what is the process by which you deliver that? Because you might have one side that really wants to come in and say it, and the other side's going, oh, no way, no way, I'm not getting in the same room. You know, that's a little harder. Then you do have to be the messenger with that stuff. Or it doesn't get delivered, you know, and it becomes an obstacle. So,
true even in the big, giant corporate mediations?
Yeah, but boy, I don't see that as a piece of it very often. They don't much give a rip whether the other side hears them or not.
My fear is just that we make assumptions about what it's about for them, and Sure, it's about the bottom line to a certain extent, in my experience, to a certain extent, and sure, it's also a little bit about these dynamics and wanting to be understood by each other and being angry at each other as well. And so that's where I'm just nervous about the idea that mediators do see it as, in order to appear competent, we kind of sometimes have to act like we know where it's going, and we have to say things that sound sort of wise, like if you're both equally dissatisfied, that's a success.
I didn't think that sounded wise.
Oh, good, okay.
Please. Let's get, no.
It's realistic, though, or something, right?
Well, whatever. I mean, it's just like, no. I mean, if they're going to be positional, and that's where they want to stay like that, then I'll say, yeah. You know, I mean, I'm not going to, because if I say to two people who've already said to each other, then really I don't like you, and I don't like you very much either. And so, you know, I'm not going to say, well, I hope we can get a settlement here. Really.
Thank you, everybody.
You're welcome.